right. Well, speaking of professors, we're going to get a little history lesson today. Our speaker is Mr. Ryan Walters from the McAlester area. He is an advanced history teacher, and he's going to talk to us today about judicial review and the myth of judicial supremacy. So I would also say that there have been Dan Fisher volunteers in McAlester and visited his church with pamphlets, and they were very well received, and even the elders of the church said, "This guy is great." So more anecdotal evidence that it works. Hey, so put your hands together. Welcome, Mr. Ryan Walters.
Thank you, guys. How do I sound okay? Everybody can hear me all right? If I hold the microphone about right here? Okay. Absolutely, yes. I was talking to Michael before, and yes, my church, it was very well received, so you guys are doing a great job. I came here today to talk to you guys about the federal judiciary, because, a little closer? Okay. Because, as we all know, we have the Declaration of Independence, which endowed us from our Creator with certain inalienable rights. The right to life, liberty, and the pursuit of happiness, our founding document. We then go on, and our founders create the Constitution of the United States to ingrain how that government will be put together. They set up very specifically through the branches that we will have a legislator that has legislative powers, an executive that has executive powers, and a judiciary that has judicial powers. And through this, they have a structure with which law can be created, amendments can be added to the Constitution, and then in the end they said the courts can do whatever they want and they can make whatever right they perceive. They can change any law at any whim with a simple majority. Is that how our system... Okay, good. I'm glad I got some laughter there, because that is not true. But that was how you'd be led to believe it works. And that is how it's been received. That's how it's been received by much of our government officials today. Is that whatever the courts deem, that is law. You would almost believe that here's how a bill becomes a law. That it's passed through the House, through the Senate, it's signed by the President, and then it goes to the judiciary for a veto. That is simply not the way the founders intended for this to be. So I'd like to go through this today and provide some background as to how did we get to this point, what was the intent of the founders and the way the judiciary would function. And I want to start this off with these 7 core principles. Now, I teach government. This is our textbook gives these 7 core constitutional principles. We first of all have a principle of limited government. That's laid right out in the Declaration of Independence, talking about that you're going to have a government by the consent of the governed. You see that in the Constitution itself through the articles on the limitations of government. That it's very clear what the powers will be, and we'll go through those in a minute. The next one is republicanism. Each state is required by the Constitution to have a Republican form of government. Now, not Republican in the sense of the party, but in the sense of elected officials will determine the policies. Popular sovereignty. And this is going to be key. That the people decide the course of our political decisions. That the people decide the course of our political decisions. I'm going to come back to that one in a minute. Separation of powers. We have these 3 powers. The founders relied heavily on a philosopher named Charles de Montesquieu that said, you can't have the same people that write the law and enforce the law. Because if they create a law to identify one individual, to punish him, nothing will stop them. You have to separate these powers. And by the way, that same philosopher, Montesquieu, also said the judiciary power is, quote, next to none. I'm going to tell you what he meant by that. Here as we go. We have a system of checks and balances. The founders knew, and by the way, part of what makes the Constitution such a great document is they understood human nature. And they understood that if you allow people so much power unchecked, as Jefferson said, if men were angels, we wouldn't need a government. And if a government were made of angels, we wouldn't need checks on that power. But as we all know, human nature would be power corrupts. We have to make sure there's a check in this system. So there's a system of checks and balances. We also have a federalism principle, which is that not everything is decided at the federal level. Okay, the 10th Amendment, which is often forgotten today, is the powers not delegated here in this Constitution are reserved to the states. so that that decision is made locally. These are core principles of the Constitution. And then the last one that you're going to see is judicial review. Now, I put a little question mark on there because I'm not going to question that there's not a power of judicial review, but I am going to question the way that it's implemented and the way that it's perceived by much of the public. So here's what the Constitution looks like. Our legislative branch is laid out in Article 1. We have there the powers that are given to that branch of government. They are to legislate. They are to make laws. There is a specific, if you look in Article 1, Section 8, powers that are delegated to them. There are only certain things they can regulate. There's only certain things they can make law on in the federal legislature. Article 1 is about 2,000 words. Second branch of government will be the executive. They will execute the law. They will enforce the law. There is a 1,025-word description of these executive powers. Commander-in-chief. That's one of these enumerated powers as well. And then I want you to notice Article 3. Article 3 lays out the powers for the judicial branch. Article 3 is 377 words long. It is much shorter than the other two. That's very intentional. They're not given very many direct powers. Nothing compared to what's given to the legislature and to the executive branch. Now, to see what these powers were intended to be, what these branches were intended to look like, I'm going to go now to the Federalist and Anti-Federalist papers. So when the Constitution is attempted to be ratified by the states, there is an intense debate. And each state has to determine whether they want to ratify it or not. So we have individuals like James Madison, Alexander Hamilton, John Jay. They begin to write these newspaper articles. These are the Federalist Papers. Here's what this Constitution will do. This is why these are of great importance. They take us between the notes from the Constitutional Convention and the Federalist Papers. We have a great understanding of what the intent of the founders were. So by the way, when people say, you really don't know what they meant by that language, that person is being very facetious or misleading, because we have a ton of notes that James Madison took during the Constitution, and we have the Federalist Papers, and then we also have Jefferson's letters. So I'm going to refer to all three of these next to indicate exactly what the intent of the judiciary was. That's the purpose of my talk today is the judicial branch. Now, by the way, you would really love an anti-federalist writer named Robert Yates. He's an attorney out of New York, and the first thing he cues in on is this judiciary. They're not elected. That is a major concern to him, because if they're unelected, and so they obviously don't stand for re-election, how would they be checked? So Alexander Hamilton, which by the way, I love to pick Alexander Hamilton, because by the way, our left-wing friends love Alexander Hamilton now, right? He's in vogue. There's a play about Alexander Hamilton. They love Alexander Hamilton because Hamilton oftentimes was arguing for a larger government than his peers. But I want you to see how Alexander Hamilton responded to the concept that the judiciary would be this over-powerful branch of government. In Federalist 78, Alexander Hamilton said, the judiciary, on the contrary, has no influence over either the sword or the purse, no direction either of the strength of the wealth of society, and can take no active resolution whatsoever. It may truly be said to have neither the force nor will, but merely judgment, and must ultimately depend upon the age of the executive arm for the efficacy of its judgments. Why are you worried about the judiciary, Hamilton says? They don't have force like the executive branch. They don't have the ability to allocate money like the legislative branch. What are they going to do? Okay? They have to rely on their judgments, that they are effective, that people see the logic in their decisions. Robert Yates is not buying it yet. Robert Yates writes, but who will check them? Robert Yates writes, Anti-Federalist 15 says, there's no power above them except for God. There's no earthly power above them. So Hamilton responds again And you can see his frustration with the next Federalist paper, Federalist 81, about a rogue judiciary. Alexander Hamilton says, and I apologize, I know this is a longer quote, but I want you guys to see it in its entirety here in Federalist 81, 1788. It may in the last place be observed that the supposed danger of the judiciary on the legislative authority, which has been upon many occasions reiterated, is in reality a phantom. That this belief that they're going to be like a legislator, that's a phantom. Particular misconstructions and contraventions of the will of the legislator may now and then happen, but they can never be so extensive as to amount to an inconvenience. They will never even amount to be an inconvenience if they tried to do this, or any sensible degree to affect the order of the political system. This may be inferred with certainty. How can he say that you can be certain of it? From the general nature of the judicial power. The general nature of the judicial power, a court can only rule on a case that's brought to it. So that, in the first part, leaves it very limited. You have to bring the case to them. Secondly, he says, from the objects to which it relates. And I think there's a great deal of misunderstanding about this. Any law student wouldn't disagree with me on this. When a court rules, they have authority over the plaintiff and the defendant in the case in front of them. They technically do not strike down a law. What they say is, we're not going to apply this law to this individual before us. Okay, so they say this law has been passed, but you say that you really didn't violate it. Well, me as a judge, I don't really think you did, so my ruling is for the plaintiff or the defendant. But they technically don't have any power beyond that. Now, the first thing I'm sure you're thinking, well, but how do they strike down these laws? Well, other courts use them as precedent. And so what they say is, well, if they said that that law can't be applied to John Smith over here, then I guess it can't be applied to anybody, so I guess we'll just all recognize it as that law basically being useless now. But technically, the power they have are for the two people in front of them, the two parties in front of them. That's what their technical power is. From the manner in which it's exercised. How do they exercise their power? What did Hamilton say in 78? The executive. They have to rely on another branch to execute their power. And from its comparative weakness, Hamilton says this multiple times. They're the weakest branch of government. I mentioned Montesquieu said, hey, their power is next to nothing. They only have power over the people in front of them. As a matter of fact, the first Chief Justice of the Supreme Court, John Jay, is asked to be the fourth Chief Justice of the Supreme Court. They ask him to come back, and he says, no, we don't do anything. You can read his letter back to the executive branch. We don't do anything. It doesn't amount to anything. We hear a case now and then, but I'd rather have some other position in government. Let that sink in for a second. The Chief Justice of the Supreme Court doesn't have much power. It's interesting, isn't it? And then lastly, he says, from its total incapacity to support its usurpations by force. It's very clear what Hamilton's saying here. If they made a bad ruling, if they acted outside of their realm, they have total incapacity to support that usurpation. Usurpation meaning they've taken a power that isn't rightly theirs. How could they ever enforce it without the executive branch? The executive branch then would not enforce it if it was a violation of the Constitution. So now, I'm going to read you just a few dissents. Now, there was a major case on gay marriage in 2015. And I'm not here to get into politics of whether we agree with that as a political decision or not. But I think it's clear that the court had no role in deciding what a state defined as marriage. As a matter of fact, I thought I can say that with certainty because that's what they said 2 years before. In 2013, when the Supreme Court said that DOMA, the Defense of Marriage Act, was unconstitutional, they said, well, you can't tell the states what marriage is. And then 2 years later, they said, but we will tell the states what marriage is. And what's very interesting about this case is you have 5 justices that say, yep, this is, marriage is, you can't define it as between a man and woman. And you have 4. You have 4 justices of the Supreme Court that don't only say that they think it's wrong, they all 4 say this has no basis in the Constitution. Here's John Roberts, Chief Justice of the United States Supreme Court, in his dissent on the Obergefell-Hodges. This is the gay wedding case. If you are among the many Americans of whatever sexual orientation who favor expanding same-sex marriage, by all means, celebrate today's decision. Celebrate the achievement of a desired goal. Celebrate the opportunity for a new expression of a commitment to a partner. Celebrate the availability of the benefits, but do not celebrate the Constitution. It had nothing to do with it. Samuel Alito, I think, goes a little bit further in showing us how we got to this point. Samuel Alito, in his dissent on Obergefell-Hodges, said, today's decision shows that, and again, I apologize for the long quote, but I want you to see this in its entirety. Today's decision shows that decades of attempts to restrain this court's abuse of its authority have failed. A lesson that some will take from today's decision is that preaching about the proper method of interpreting the Constitution or the virtues of judicial self-restraint and humility cannot compete with the temptation to achieve what is viewed as a noble end by any practical means. I do not doubt that my colleagues in the majority sincerely see in the Constitution a vision of liberty that happens to coincide with their own, but this sincerity is cause for concern, not comfort. What it evidences is the deep and perhaps irremediable corruption of our legal culture's conception of constitutional interpretation. Now, I know that's a long one, but I think he really says it well. That at this point, is it irremediable? Have justices bought into the belief that they determine what is constitutional and whatever their own eye sees it to be, not in the actual founding documents? So when we look at this, how could we have gotten to this point? Can anybody have predicted it? I want to say in 1820, Thomas Jefferson is absolutely pointing out that this issue could occur if the American people were not wary of it. So this is Thomas Jefferson's letter in 1820 to William Jarvis. To consider the judges as the ultimate arbiters of all constitutional questions is a very dangerous doctrine indeed, and one that would place us under the despotism of an oligarchy. The Constitution has erected no such single tribunal. Okay, this is not what we designed. We did not leave a monarchy, controlled by one person, to come to America to set up to be ruled by just a few people. That is not what we did here. That goes contrary to the principles that we just laid out about the Constitution itself. Now, I want to address two court cases here, because the first thing that you're going to hear is, well, whatever they said in the beginning, it was all thrown out the window in 1803 because Marbury versus Madison set up judicial review. And when Marbury versus Madison happened, now the courts can say something's unconstitutional, boot, it's gone, and now there's nothing we can do about it. I would like to challenge that for a second. Marbury versus Madison is a case that's very, very political. I'll just start it off that way. John Adams is president. He's on his way out. He decides that he's in the Federalist Party. Thomas Jefferson is calling it the Revolution of 1800. That when I come in with the Jeffersonian Republicans, hey, all this, you guys usurping power, using power, I think, in an inappropriate way, that's over. We're going to bring power back to the people. He calls it the Revolution of 1800. When Jefferson beats Adams, and by the way, it was a particularly ugly political battle. Adams does what he calls what is known as the midnight appointments. He appoints all these judges and justices of the peace on his way out to make sure all of the Federalists still will hold these positions. Well, when Thomas Jefferson takes over, they haven't been all given. And so James Madison, Jefferson's Secretary of State, refuses to give the rest of them away. They ran out of time and said, I'm not going to give out these to all your friends. I'm not going to do it. So anyway, this goes all the way up to the Supreme Court. And John Marshall is the Chief Justice of the Supreme Court. Very interesting fellow in all of this as well, especially when you consider he was the Secretary of State. When these appointments were, it gets very convoluted politically. But I'm going to skip to what's most important. What's most important here about this case is that John Marshall's decision is going to be that the Judiciary Acts of 1789 that created these positions, okay, is unconstitutional. And so he can't force the president, Thomas Jefferson, to hand them out because the original law that allowed this to happen was unconstitutional. Now, the conventional view of this is, well, there you go. Say the Supreme Court can determine constitutionality, and that's all that matters. And then, guys, Cooper versus Aaron is going to come along over 100 years later, and the court is going to double down on this. They're going to say, and this is in the ruling in Cooper versus Aaron, the court stated in this ruling that Marbury versus Madison, quote, declared the basic principle that the federal judiciary is supreme in the exposition of the law of the Constitution. And this principle has never since been respected by this court and this country as permanent and indispensable feature of our constitutional system. So this is where this comes from. Okay, you have this case, Marbury versus Madison. You have this other case, Cooper versus Aaron, where the court comes in and says, hey, it's the supreme law of the land. That's what you got to do when we make a decision. And I do want to be, we should always be wary when the people in power say that, hey, we have the supreme, what we say is supreme and over everything else. I think that should be a red flag, right? But they have declared this as their supreme law of the land. Now, I'm going to challenge them on this. I don't think this is what Marbury versus Madison said. This is from John Marshall's decision. Yes, he did say that the Judiciary Acts were unconstitutional, but I want you to notice the way that he says they're unconstitutional and why he can't apply them. It is apparent that the framers of the Constitution contemplated that instrument as a rule for the government of the courts as well as the legislature. He's talking about his oath of office. Why otherwise does it direct the judges to take an oath to support it? Why do they make us swear an oath to the Constitution if I'm not supposed to pay attention to what the Constitution says? This oath certainly applies in an especial manner to the conduct in their official character. How immoral to impose on them if they were to be used as the instruments and the knowing instruments for violating what they swear to support. John Marshall isn't claiming that this is some power that only he has. He's saying, I have the same obligation the president has and Congress has, that I've sworn to uphold the Constitution of the United States. And if you bring me something that violates the very character and understanding of it, I can't now enforce that law. He's saying I have it also, not I have it exclusively. And I think that's an important distinction to make when we move forward here with dealing with courts that operate outside of this. We're going to come back to that oath of office here in a minute. Now, you might even say, well, so what? So what a court in 1803 says that? So what a court in 1950 says that? What difference does that make? Now, this is very important as to why we deal with these struggles. Once the court makes a decision, there's no going back. That's the understanding today. Well, first of all, we need to separate the Constitution from constitutional law. The Constitution is what it says it is. Okay? It is the document. We can all read it. It is right there for us. Constitutional law, a term you're going to hear a lot in law schools, a term you're going to hear a lot applied in Supreme Court cases, is what the Supreme Court says about the Constitution. That is their rulings. Now, their rulings make up over 500 volumes of cases. So there's all these cases you can read. What did the Supreme Court say about the First Amendment? What did they say about the Second Amendment? What did the Supreme Court say about the Fourth Amendment? And I'm not saying that these aren't important, but there's something that we need to remember. Edwin Meese was the Attorney General to Ronald Reagan. And he did a series of speeches on this. And he thought that there needed to be clarity brought to this. Here's a quote from Edwin Meese, again, Attorney General to Ronald Reagan. In terms of sheer bulk, constitutional law overwhelms the Constitution. Constitution fits on a few pages. Obviously, we have 500 volumes of these cases. But in substance, it is meant to support and not overwhelm the Constitution whence it is derived. This is not the law. This is their support of the law, explaining it, talking about, by the way, cases and controversies that come before the court. That is what the court is to hear. Cases and controversies that arise underneath our laws. Did this person technically break the law? That's what a judge is to determine, the controversy of that individual circumstance. So, first of all, we need to understand that that's why these Supreme Court cases are viewed as important, because they set constitutional law, which is their interpretation. And then there's this term, this law term, this stare decisis. It comes over, it's a Latin term that means to stand by things decided. And this is where precedent comes in. Because if a court says something, if they make a statement, they claim that that is the new precedent. So if a similar case comes before them, they can say, well, we already decided that. We just ruled on that just 2 weeks ago. So we'll let that decision stand. We're not going to overturn what we've already stated. Now, in general, I think that's a smart practice, in that you don't want the laws applied to individuals different every day, right? In general, we want a judge that's going to apply the law the same. That is, if it was applied correctly the first time. Because if it wasn't followed right the first time, and then you say, sorry, boom, we just follow what we did before, that is a very dangerous way of thinking. So if the ruling is fair, if it is right, if it is just, absolutely, continue to follow it. But if it's not, do not. In 1857, the Supreme Court ruled that African Americans were not citizens of the United States in the Dred Scott v. Sanford case. And we were told it was the law of the land. And so what ends up have to happen before that is received by the rest of the country? There's a civil war fought. The Supreme Court stands down and says, hey, sorry, we determined this. We read the Constitution and it says black people aren't citizens. That's the way we read it. So the rest of you guys don't start, sorry what you think now. That's what we determined to be the law. You see how badly Plessy v. Ferguson, segregation, it is absolutely constitutional. So when they make a wrong case, if you followed this, it wouldn't take you very long to see why this would be problematic. Because then you could never go back and overturn it by their own logic. So what can be done? Okay, you've heard Justice Alito's statements. You've heard irrevocable that cannot be fixed. That maybe we've gone too far. I want to throw some suggestions out here to you, and I want to give you some examples of some things that can be done to a court, to a system that has usurped legislative authority. You always hear, well, let's just elect better judges. Well, that sounds good, and I don't disagree. I would obviously like for us to elect better judges, but that is becoming increasingly difficult to do. Anthony Kennedy, the justice that wrote the majority opinion in the Obergefell case, he was nominated by Ronald Reagan. And by the way, Ronald Reagan, from all that I've read, took his appointments to court very seriously. He had Edwin Meese. There is a conservative TV host right now, Mark Levin. He worked in the Justice Department under Edwin Meese, under Ronald Reagan. They took that very seriously, who their nominees would be. And yet, here we have Justice Kennedy, that he is doing a lot of the usurping in his opinions. It's very difficult to find a judge. And by the way, President Trump nominated Mr. Gorsuch to the court. And we hope he's great. But it's so difficult to find these good judges and know what's going to happen in 5 years. Judges should reject erroneous precedent. This needs to be something that is asked of these nominees. Gorsuch was asked about Obergefell and Hodges. Gorsuch was asked about Roe versus Wade. And he said, I'm not going to go back and overturn them. They've been decided. See how dangerous that is? That precedent that we're not going to... Now, I'm going to tell you, Clarence Thomas... He will go back. If you read what he says on a case, he'll go back and say, it's wrong now. By the way, you got it wrong 20 years ago. Then, by the way, you got it wrong 50 years before that. He puts it all in his decisions. Hey, I'll show you. It was wrong when you did it 10 years ago. It was wrong when you did it the first time. And that's what you need to see is, hey, we're going to take this apart systematically from where you first got it wrong. Okay, precedent doesn't apply if the ruling is erroneous. We need to impeach judges. We need to impeach these judges. That is absolutely constitutional. Thomas Jefferson tried to do it to Samuel Chase and fell just short. Okay? And Samuel Chase was saying things from the bench that Jefferson deemed as inappropriate. They were really political statements. He was being very critical of a lot of what Jefferson was doing. And it was a political situation where a judge was just really mouthing off and issuing rulings. It didn't seem to have any precedent in the law. And so Jefferson says, hey, Congress, let's go. Let's get this guy out of here. This is dangerous. And guys, he's on the Supreme Court. So he attempted to impeach a Supreme Court justice. That can't be done. It's absolutely constitutional. We could do that. We could do that with federal judges. So when a federal judge says, Mr. Trump, even though in 1950, and no matter what we think about immigration, in 1950 we had Supreme Court Justices Frankfurter who said, there's nothing more settled in case law than that immigration is a plenary power of Congress. Congress, they can do whatever immigration policy they want. They say the president can exclude individual members. And then all of a sudden we have a federal judge in Hawaii that says, no, you can't, Mr. Trump. You can't do that because this guy says he feels like... By the way, he was not rejected immigration. His family wasn't rejected immigration. In the Hawaii case, they felt like it might happen in the future. Federal judge says, that's good enough for me. That's got to go. Now again, this is, and no matter where our politics fall, I want you to notice, these political decisions were meant to be made popular sovereignty through the people. We decide our policies. There's a reason why the 10th Amendment reserved the power to the states and the people respectfully. So not only, guys, do we not have a legislator and executive making these decisions for us, we've got 5 of the 9 justices that will never run for election. They'll never face what they do. They can make a decision and they can move on. We can limit a court's jurisdiction. Article 3, Section 2, again laying out the judiciary's powers. Congress could tomorrow say, you're not going to hear any more cases on abortion. Sorry. They could do it. They could limit them. You're not going to hear any more cases on immigration. That's going to go straight to the Supreme Court. You federal judges, you're not going to do that anymore. That's absolutely in the Constitution. They could do that tomorrow. Congress could if they wanted to. We could abolish federal courts. Thomas Jefferson abolished 9 of the 13 federal courts. So, I mean, we don't got to abolish 9, but what about 1, 2? How about when they make these really bad rulings, you bring them before Congress, get them to explain their decision making? And if it's completely divorced from the law, you say, okay, well, we're going to remove you from office, or as a matter of fact, if this court's going to continue to act in this way, we don't need this federal court anymore. The only court put together by the Constitution is the Supreme Court. Congress creates the other courts. So think about how strange it is that we have these courts that are created by Congress. Most of what I've talked about today is the Supreme Court. But we have courts that are created by Congress that are taking out federal policy when Congress could literally abolish them. I mean, they could be gone tomorrow. It's obviously very divorced from what the original intent was. Now here's the one that I told you I was going to come back to. And the one that I don't feel like is talked about. There's a great writer for Conservative Review named Daniel Horowitz. He wrote a book a few years ago called Stolen Sovereignty, that the court is taking away the rights or the ability of people to settle their political decisions. And he brings this up. I think it's a great point. What did Marshall say? Marshall said, I can't enforce this law because I took an oath to this Constitution. Do you know who else takes an oath to the Constitution? Your president does. Your congressmen do. Your governors do. They all swear to uphold the Constitution. So why don't they apply what John Marshall said? Hey, courts, I'm sorry, but I too have been sworn to uphold this Constitution. And if you're going to force me to act in a way outside of what the Constitution says, I'm not going to enforce that. I think I've got a pretty good example of someone who did that. Abraham Lincoln. Abraham Lincoln is in his Senate debates with Stephen Douglas. And Stephen Douglas, they ask him about Dred Scott. And I say, hey, we had these compromises. We had the Missouri Compromise. We were kind of going in the right direction. The Supreme Court said the Missouri Compromise is unconstitutional, and they said, hey, black people are property, and so there's really nothing we can do about it. And the moderator asks Stephen Douglas about this, and he says, that's the law. The Supreme Court said it, so that's what we have to do. Notice Lincoln's response in their debates. And he's talking about Stephen Douglas here. He says, he swells up and says, all of us who stand by the decision of the Supreme Court are the friends of the Constitution. All you fellows that dare question it in any way are the enemies of the Constitution. And the manner in which he adheres to it, not as being right upon the merits as he conceives, but as being absolutely obligatory upon one simply because of the source on which it comes. He's saying, look at Stephen Douglas. Look at what he's saying. He's saying it's right because the Supreme Court says it's right. He's not saying it's right because of the merits of their decision. And then notice where Lincoln says this would lead to. It marks in this respect that it commits him to the next decision, whenever it comes, as being obligatory to this one. Since he does not investigate it and won't inquire whether this opinion is right or wrong. If he's not even going to think about it, if he's not even going to research it, if he's not even going to take the time to analyze, is this really what the Constitution says? Then I guess, what if they decide something crazy tomorrow? What if they decide something crazier next year? If he says whatever they say goes, where is this headed to? And Lincoln didn't just drop it after this debate. His first inaugural address. So Lincoln has been elected, 1860. Lincoln stands up March 1861. And here's his first speech to the country. The candid citizen must confess that if the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the instant they are made in ordinary litigation between parties and personal actions, the people will have ceased to be their own rulers, and having to that extent practically resigned their government to the hands of that eminent tribunal. That if we're just going to base, I think it speaks for itself, doesn't it? That if we are simply going to just agree to whatever they say because of who they are, I guess they're our eminent tribunal. I guess they're in charge now. It's Abraham Lincoln. So if Lincoln was willing to stand to the courts, if I've just laid out, and again, these are ideas that come from all over the country. Again, I mentioned Daniel Horowitz. He puts a lot of these ideas out here. I would encourage you to read his book if you like some of those concepts. But why haven't we been acting on these things? Roe versus Wade was 1973. Why haven't these things happened? I think there's a couple of interesting thoughts on maybe why we haven't seen more pushback from people. This is James Madison. Spencer Roane is a great justice. He never made the Supreme Court. But James Madison, in his correspondence with Spencer Roane, said this: it is not probable that the Supreme Court would long be indulged in a career of usurpation opposed to the decided opinions and policies of the legislator. Nor do I think that Congress, even seconded by judicial power, can, without some change in the character of the nation, succeed in durable violations of the rights and authorities of the states. Madison could never envision the court getting out of control unless there was a change in the character of the nation. Larry Kramer, again, I'm going to tell you another great book to look into. He was the dean of Stanford Law School. He wrote a book called The People Themselves, Popular Constitutionalism and Judicial Review. And I think he speaks to this idea of the character has changed in the way people question the court and the way people understand the Constitution. Larry Kramer. Neither the founding generation nor the children nor their children, nor their children's children, right down to our own grandparents' generation, were so passive about their role as Republican citizens. They would have did not accept, being told that a lawyerly elite had charge of the Constitution. And they would have been incredulous if told, as we are often told today, that the main reason to worry about who becomes president is the winner will control judicial appointments. something would have gone terribly wrong, they believed, if an unelected judiciary were being given that kind of importance and deference. Perhaps such a country could still be called democratic, but it would no longer be the kind of democracy Americans had fought and died and struggled to create. So I'd like to end with that quote. And you see this universal of acceptance of anything the courts decide is relatively new. We did not see that in the founding era. We didn't see it for 100 years later. So the question I would like to leave you with as we talk about the judiciary today, is there anything, any ruling the courts could make that people, elected officials, nor average citizens not holding government office, that would say, no, I can read the Constitution, we can read the Constitution, that's not what the Constitution says? Is there anything that they could decide that would breach that boundary? Because we've got Roe versus Wade. We've got these policies coming from the federal courts. So is there any, where's that line? That's kind of what I'd like to leave you with. Is any decision they make going to be followed by all elected officials? Thank you guys for your time.
Thank you. Thank you very much. That was great. We have a Holocaust. We have millions of people getting butchered every day throughout the years. That's the line. You're exactly right. We've already crossed it, and there's no going back. This union of states will be judged, and any community that doesn't repent will be judged. And I don't have $1 million to make this statement all over our state, or millions of dollars to make it all over the country, but the election next Tuesday is the most important election in our lifetimes since Roe v. Wade. I imagine there's going to be a day, and I hope it's in our lifetimes, when here in the United States of America, somewhere, we will have a Holocaust museum of our own, because we will have stopped it. And then it will be about remembering and doing it no more. And in that museum, you're going to see T-shirts like this and like that. And they're going to be showing on endless loops the campaign commercials of Dan Fisher, who said, I will stop the slaughter of innocent human beings in my jurisdiction. And if our state doesn't rise up and support that message and that mission, then we're complicit, and God will judge us with the rest of our filthy nation. With that high note to end on, Ken Blood, why don't you come on up and close us in prayer? Hey, next week what we're going to do, it's the day after the election. So we will go through all the different races. We'll look at how our endorsed candidates did and our picks. We'll look at who's left in a runoff and what all that will hold for us the rest of the summer. That'll be next week. So come back ready to celebrate and cry with us.
Gosh, thanks. Before we say the closing prayer, this is the first teacher that I've met, I've liked in a long time. And you deserve a raise. All right, if you'll bow with me. Lord God in heaven, maker of the heaven and earth, thank you for giving us this day. We pray for this state. We pray that you build mighty things out of small things, and that you would let the efforts of the godly be heard. We ask that their ears would be open, their eyes would be open, and that good things come out of the upcoming election. In the name of Christ I pray, amen.